We will hear argument first this morning in Case 21-954, Biden against Texas. General Prelogar.
Mr. Chief Justice, and may it please the Court. The Secretary of Homeland Security exercised his statutory discretion to make a policy judgment. He found that the benefits of MPP were outweighed by its domestic, humanitarian, and foreign policy costs. Yet the lower courts ordered DHS to reinstate MPP in perpetuity, requiring ongoing negotiations with Mexico to send thousands of non-citizens into its territory. That was error. On the first question, Section 1225 confers a discretionary return authority that the Secretary may use, not a mandate. Nothing in the statutory text or history compels DHS to use MPP whenever Congress fails to provide sufficient funds for universal detention. Respondents identify no one who interpreted Section 1225 this way before this lawsuit, no member of Congress or executive branch official or anyone else. And on this reading, every presidential administration in an unbroken line for the past quarter century has been an open violation of the INA. The Court's interpretation compels sensitive foreign policy negotiations and would require transformative changes to the government's border operations. If Congress had wanted to mandate those results, it would have spoken clearly. On the second question, respondents have abandoned virtually all of the district court's reasons and the Fifth Circuit's reasons for finding that the October 29 termination decision has no legal effect. Texas now concedes that DHS was permitted to respond to the district court's remand by issuing a new decision. That's just what the Secretary did following a multi-week reconsideration process. Respondents claim that the Secretary didn't really have an open mind in that process, but the APA doesn't impose an amorphous open-mindedness requirement, and respondents have not carried their heavy burden to show that the October 29 decision was pretextual. This court should reverse the judgment below, and the Secretary should be allowed to finally put his policy decision into effect. I welcome the Court's questions.
General, below you argued 1252F1 and this limitation on who can impose injunctions here. And it seems as though you've abandoned that. But what should we do with that provision in this case?
Well, Justice Thomas, we included a footnote in our opening brief in this case to make clear that we were continuing to press our Section 1252F1 argument. Of course, we recognize the Court is considering that issue in the Aleman-Gonzalez case, but we continue to adhere to the position that the district court in this case had no authority to enter the injunction that it did because that would enjoin or restrain the operation of the INA, and only this Court has jurisdiction to enter an injunction like that.
You emphasize the foreign relations concerns that arise in this case, but we've said in previous cases that Congress has plenary authority in this area. Beyond that, what if Congress has already legislated in this area and expressed those concerns, then what additional concerns should we take into account?
Well, Justice Thomas, I think that the particular interpretation of the statute that the district court adopted here implicates grave and serious foreign policy implications. Of course, the executive branch has primary responsibility for managing foreign relations and conducting those kinds of negotiations. And I think that if Congress had intended to override the executive's ordinary discretion that it enjoys with respect to that kind of foreign policy relationship, then at the very least it should have made that intent express in the statute. But instead, if you look at the text of Section 1225B2C, this is the contiguous territory return provision, what Congress said is that the Secretary may return. Congress in no sense indicated that it was actually imposing on the executive a mandate to engage in those kinds of ongoing negotiations with Mexico, not just to obtain its consent at the outset, but the enormous investment of diplomatic resources that it takes to engage with Mexico on a day-to-day basis to implement this policy, then Congress should at least have said that clearly in the statute.
But I think their argument is that it was I apologize for interrupting you, but I think they suggest that there's the underlying rule that Congress, that you shall detain. And the shall, I think they see as a baseline, and then the others are there's limited discretion to parole or to do other things. But it seems as though they think that discretion is consumed by the shall.
Well, Justice Thomas, let me respond to that in a few different ways. I want to emphasize at the outset that we think that DHS is relying permissibly on its express statutory release authorities here. So it's the parole authority you mentioned in 1182D5. It's also the authority to grant bond or conditional parole under Section 1226A, which is a provision that respondents largely ignore. So we think that the releases are consistent with those express authorities, and we think that the language in 1225B2A, the shall be detained language that you referenced, should be interpreted against the backdrop of longstanding principles of enforcement discretion in recognition that this is essentially a limited law enforcement resource. No one disputes that DHS does not have sufficient capacity to detain everyone who could be subject to detention under that provision. But I should say also that if you disagree with everything that I just said or think that there is more room for doubt about how DHS implements those detention and release authorities, still I don't think that provides any license to rewrite Section 1225B2C in contravention of its plain language. Congress said there may return. It didn't create the kind of mandate that respondents are now reading into the statute.
Well, I mean, you say if we disagree with you on the other grounds, that's not a basis for adopting an erroneous interpretation of the third provision. But where does that leave us? I mean, I am sympathetic with your position, which is that you can't detain enough people. You don't think you have to send people back through the return mechanism, and that's fine, I would say. One way to look at it is you're sort of taking away from yourself an option to comply with the statute. And then it gets to a question of the parole, interpretation of the parole provision, and whether or not I think significant public benefit can accommodate as far as you want to stretch it. So if I get to the point of looking at this and agreeing, basically saying there's nothing you can do given the statutory requirements, it's not — you're in a position where the facts have sort of overtaken the law. But in that situation, what are we supposed to do? It's still our job to say what the law is. And if we say what the law is and you tell us we can't do anything about it, where do you think that leaves us?
Well, I would say at the outset that to the extent that the court is inclined to say what the law is with respect to the detention and release authorities that you mentioned, 1225B2A, parole, I think that those should be challenged on their own terms if respondents disagree with how DHS is implementing those provisions. And instead, respondents said in the district court that they weren't even challenging our parole policies. Any judicial relief that could be necessary in that context should focus on those provisions. But
well, but I mean, let's go through them. You don't — the detention is not — it is a 2% answer to the problem. So we can put that to one side. I don't think they have to challenge detention for the reality to be there, that's not going to help you get to where you need to get. And with respect to the others, again, assuming that I find significant public benefit to be a more substantive restriction than perhaps you do, I guess, again, where does that leave us?
Well, I think it would leave the court.
If you have a situation where you're stuck because there's no way you can comply with the law and deal with the problem there, I'm just wondering why that's our problem. Our problem is to say what the law is. And if you're in a position where you say, well, we can't do anything about it, what do?
Well, I agree that it's not your problem in this case. I think that to the extent the court interpreted the provisions along the lines you're suggesting, that could at most support a judicial order that we need to detain more people or we need to change how we're releasing people. But again, I would go back to the central issue in this case. The court's responsibility here is to look at how the district court interpreted the contiguous territory return provision. And none of those concerns about detention and release could in any sense justify transforming that position contrary to Congress's plain language, the may return language, with all of the consequences that would have for our foreign relations. So I think the simplest route to resolving this case is to say that. I don't think the court actually needs to say anything more. It's not necessary to resolve any of those questions about the meaning of 1225B2A or 1182D5 or 1226A. All the court needs to say in this case is that the contiguous territory return provision does not carry the meaning that justified the district court's injunction in this case.
General. May I ask you about the jurisdictional question that Justice Thomas raised? You argue that we lack jurisdiction because the district court lacked jurisdiction. You devote 2 sentences in a footnote to the question. I want to see how far your jurisdictional argument goes. So do you think that 1252F1 barred the district court from vacating the Secretary's decision to stop using 8 U.S.C. 1225B2C authority to return aliens to Mexico?
Well, I think, we focused on the injunctive relief in this case, and I think that there's an additional question about vacatur. I do believe that our arguments would extend to that as well. To the extent that you're worried about the extent of the briefing in this case, I would, of course, refer back to our briefing in Aleman-Gonzalez. We also briefed
I'm very well aware of the briefing in that case. It doesn't say anything about the APA, and that's my principal concern right here. So your answer is that it would prevent a district court from reviewing immigration rules dealing with the relevant provisions of the INA under the APA. The district court could not do that.
Well, to the extent that that would entail the district court in setting aside the agency's action, I do think that would fall within the bounds of our interpretation of F1.
Let me ask you this, to address this hypothetical. Suppose DHS invoked that authority, the return authority, to promulgate a policy where every alien who arrives on land from a foreign country contiguous to the United States was required to return to Mexico or Canada pending the initiation of a removal proceeding under 1229A. And then suppose DHS also promulgated a policy where neither 1229A removal proceedings nor asylum proceedings could be initiated for any of those aliens until 10 years after their removal. Okay? You get the hypothetical. Would any court besides this court have jurisdiction to hear a challenge seeking to vacate that policy?
Well, I think that, of course, there would be jurisdiction in the lower courts with respect to individual non-citizens who are raising that challenge. And that's, I think, the premise of Section F1, that Congress was trying to channel those types of claims into individual proceedings with respect to individual non-citizens. So there would be jurisdiction in that circumstance.
But it would have to be done on an individual basis. There could be no request under the APA to vacate that order, that policy saying everybody covered has to stay in Mexico for 10 years.
Well, obviously that policy could be challenged in the individual case, and so I think it could be taken on its own terms there.
Don't you think that's you might be right, but don't you think that's a far-reaching argument? Don't you think that goes well beyond anything that would come to that we would have thought about in Garland versus Gonzalez? Don't you think that deserved briefing?
Well, certainly, Justice Alito, I defer to this court in how it's choosing to resolve those issues in Aleman-Gonzalez. With respect to additional briefing, we did include briefing on this issue at the stay stage in this case as well. So I would refer to our briefing.
Did you say anything about the APA in the Gonzalez case?
I'm sorry that I can't recall right now whether we briefed that issue there. If you're telling me we didn't, I assume we did not.
On the jurisdictional question, you think that we should go back and read what you've submitted below? It wasn't important enough for you to submit it to us directly?
We did brief this issue at the stay stage in this case, and this court, we understand, denied the stay nevertheless and found a likelihood of success on the merits with respect to the procedural APA claim on the June 1st memorandum. So that's why we didn't renew our briefing on this issue at the merit stage.
Counsel, are you taking the position that 1252F1 also eliminates declaratory judgment rulings? I mean, there is a difference between issuing an injunction vacating an agency action and issuing a declaratory judgment that agency action is unauthorized and letting that come to this court to decide what remedy is appropriate, whether an injunction is appropriate or not, if you decide not to follow the statement, correct? There's nothing in a declaratory judgment rule that forces you to. You might be subjecting yourself to contempt, but you can stay that pending review by this court, couldn't you?
That's right, Justice Sotomayor. So I think that it would be possible for the court to draw that distinction and distinguish between declaratory relief and injunctive relief.
You don't see anything in the language of 1252F1 that stops declaratory relief.
I believe when Aleman-Gonzalez was argued, we suggested that was an open question, and I recognize that it's a more difficult question. Here, I think that it's clear that our F1 argument applies because we're facing a nationwide permanent injunction in this case.
Now, what do we –
I'm sorry.
Go ahead.
I just wanted to follow up on that.
Go ahead.
Okay. I would just appreciate an answer to Justice Sotomayor's question about declaratory relief in the government's position with respect to 1252F.
I'm sorry, a clarification?
Yeah.
So I'll do my best, and I should confess
does
that
it-
I didn't go back to review the oral argument transcript
Oh,
in
no, no,
Aleman
no.
Gonzalez, but I think we took the position there that it's an unsettled question how this would apply in the context of declaratory relief. And so, I want to be consistent with that position, but I recognize it's a harder issue for us, and I think that there would be a path for the court to determine that there's a distinction between declaratory relief and injunctive relief, which is, of course, the primary focus of that provision.
No, I understand it's an open question and a difficult one. I just wonder whether the government has a view on it, one way or the other.
Our view is that it also could foreclose review of declaratory relief, but I recognize the court could conclude otherwise.
Why would it foreclose declaratory relief?
I'm sorry, Justice Gorsuch. I don't have further information at this time. If you'd like us to submit supplemental briefing on this issue, we would be happy to do so to try to clarify that position.
But it is the government's position that it does foreclose declaratory relief, too.
I believe that's the position we took at oral argument in Aleman Gonzalez, recognizing it was a tougher issue.
Thank you.
If I could turn to the various textual clues and contextual clues that we think fortify our interpretation of the contiguous territory return provision in this case, there are really four key things that I want to focus on that I think demonstrate that the district court's interpretation here went seriously awry. And the first thing, of course, is the text, which was emphasized that Congress used the may return language, which is clearly discretionary. On respondents' interpretation, what Congress really meant is the Secretary may return unless detention capacity is lacking, in which case he must return. But Congress nowhere put that condition precedent into the statute, and I think it's really significant that Congress failed to do so, because on respondents' reading, this would have been mandatory from the outset and at all times thereafter. In 1996, when Congress enacted this provision, there was not sufficient detention capacity at that time, and respondents don't dispute that that has remained continuously the case. So I think it's particularly notable that their interpretation of the statute would have run counter to the text all along. I would point as well—
Is there any indication in connection with the 96 Act that anyone in Congress expected that if there was not sufficient detention capacity, that hundreds of thousands of people would be just paroled into the United States without being lawfully admitted? Did anyone say that in Congress?
I don't think that there was express history on that point, but Congress was focused on the detention issue, and it thought that the new expedited removal provisions that it had added to the statute at the same time would function to alleviate part of the strain on detention resources. So I think that history actually shows that Congress here wasn't thinking that contiguous territory return would be the solution to this issue. Instead, they were focused on expedited removal to do so. And it's no mystery about where this provision came from, contiguous territory return. It was a much narrower and more discrete problem, which was that the Board of Immigration Appeals in the Sanchez-Avila case had just concluded in 1996 that the executive's prior discretionary practice of sometimes returning some non-citizens to contiguous territory required express statutory authorization if it was going to continue. And Congress provided that express statutory authorization in 1225b2c. But there is no indication that it meant to go further and actually transform that prior practice and turn it into an ongoing mandate that DHS must implement this on a border-wide basis consistently based on a lack of detention appropriations.
Well,
Go ahead. The Fifth Circuit reasoned that didn't deny that the provision you're talking about uses the term may, but it said that if you read the relevant statutory provisions, they give DHS three options. One is to return these individuals to Mexico or Canada. The second is to detain them. Third is to have case-by-case determinations regarding humanitarian issues and public benefit. And 1220, a cornerstone of that is the 1225b2a says the alien shall be detained, right?
That's correct.
And you now read that to be discretionary in light of Castle Rock. Is that correct?
No. To be clear, Justice Alito, and I appreciate the opportunity to offer clarification on this point, we are not suggesting that that language in B2A is essentially functions as a may, that Congress didn't express a preference on this issue. What we think, though, is that against the background of Castle Rock, it's appropriate for DHS to take account of its limited detention capacity for purposes of exercising its various authorities, and that includes the express release authorities. So there's parole. You mentioned it. You left off the list, Section 1226A. We think that's another important source of authority for DHS here.
Well, what you just said sounded to me like a lot of words that means that we have discretion. We have prosecutorial discretion to decide whether to detain. Shall be detained doesn't literally mean shall be detained.
I think what it means.
Is that correct?
Well, I think in this context, what shall be detained means is that Congress expected us to use the detention capacity that we have, and that's what we're doing. DHS detains tens of thousands of individuals on any given day. Respondents' interpretation that would remove any discretion would mean that DHS can't take account of that limited capacity in making prioritization decisions. So if they're really right, and if DHS has to fill up those beds on a first-come basis, then the upshot is that it's going to run out of space and not have capacity to detain those with criminal histories or who represent a national security threat or have final orders of removal and might be particularly likely to abscond. And I don't think that's a reasonable interpretation.
Well, I'll tell you when excuse me if I ask one more follow-up. I'll tell you when I read your brief on this point, I said, wow, this is I remember the Jennings case where I had the pleasure of writing the opinion for the court. And I said, boy, my recollection is that the government's brief in that case took exactly the opposite position from what the government is taking here. And I went back and looked at it, and that is exactly the case. You stressed that shall be detained means shall be detained. I have it right before me. You emphasized the language, shall be detained. And you went on. This is a brief filed by your predecessor, Mr. Gershengorn. Unlike the word may, which implies discretion, the word shall usually connotes a requirement. And here the repeated shall be detained clearly means what it says, because Congress said may when it meant may. Congress crafted only one exception to that rule. Congress provided that the Secretary may parole into the United States any alien applying for admission on a case-by-case basis for urgent humanitarian reasons or significant public benefit.
Let me respond to that in two ways, if I could, Justice Alito. And the first is to make clear that, of course, there we were addressing a very different type of argument, which is whether Section 1225 contains effectively an implicit statutory entitlement to release on bond, which is what the non-citizens in that case were claiming. And we said then and remain of the view, and this Court said in Jennings, that that's not a proper interpretation of that shall be detained language. But we had no occasion in that case, and this Court had no occasion in that case, to consider how to interpret these provisions of the INA against the backdrop of traditional enforcement discretion principles. And I would point in particular now to the opinion of Chief Judge Sutton in the Sixth Circuit, a recent opinion we cite in our reply brief in the Arizona case, that I think has a really useful distillation of the relevant principles in this context when you're looking at those types of provisions in the INA in light of limited law enforcement resources. But the second point I'll make is that to the extent you are focused on this differential use of shall and may, I think that only fortifies our principal contention in this case, which is that the contiguous territory return provision uses that discretionary may return, and it's respondents' position that would actually fail to give effect to Congress's drafting choices by turning that into a mandate.
Do you think that as to each non-citizen, that you have to comply with one of the four, let's call them now because you added bond, that you have to comply with one of the four options that the statute gives you? Or do you think that there is a kind of residual discretion so that even if an immigrant could not be paroled under 1182, you could release that immigrant, you could still release that immigrant rather than detain him?
So I think the question of residual discretion is a difficult one, and we haven't had to process that here because we think that DHS is complying with those four statutory options. Our position is that DHS is faithfully implementing both the parole provision in 1182d5 and the bond and conditional parole provision in Section 1226A. And I think that its implementation of those provisions suffices in itself to resolve this case because respondents, as the plaintiffs, alleged and said that DHS was violating those obligations, but came forward with no evidence to substantiate that claim.
I mean, I think General Stone's position is sort of we don't need evidence because it's kind of laughable on its face to think that you're paroling this many people by using case-by-case determinations rather than, I think, his word is en masse.
Well, those kinds of arguments just don't engage with the statutory text here. 1182d5 has a procedural requirement, case-by-case adjudication. DHS does that. It does not grant parole to any individual non-citizen without reviewing the individual case and making an assessment of individualized factors like flight risk, likelihood of absconding, and whether the release of that individual would advance an urgent humanitarian reason or a substantial significant significant public benefit. And that's, of course, the substantive criteria. Our position is that DHS can permissibly take account of its detention capacity in determining that there is a significant public benefit from releasing a low-priority individual who's not a flight risk, who doesn't have a criminal history, if that would preserve a bed space for someone who's a higher priority under our detention policies.
But you were saying we don't need, or you don't need, to argue for residual discretion because you're not using any residual discretion.
That's right. We are not using residual discretion
within
here.
These four categories.
That's correct. We think that we do not need residual discretion here, and I think that it's an interesting question, but it's largely an academic one, because here DHS's release authorities amply justify what it's doing on the ground.
Counsel, can you tell me what by-case review means? You part of your answer addressed it. Each alien is interviewed?
That's right. So what
is a
DHS
background
does,
check done on them?
There's usually a criminal background check done. There's a biometric records check that's completed, and DHS reviews that information and makes judgments about things like flight risk and security concerns for purposes of administering these provisions.
I'm assuming there's a terrorist list of some sort or database that you look at as well?
I assume so as well, although I haven't checked with DHS on that.
All right. So, and you presumably you find out what ties or not the person has to the United States and whether they've absconded before, et cetera.
That's right. So by regulation, DHS is required to take into account those kinds of considerations insofar as they bear on flight risk. And the parole determination will only be made after making a judgment that the person does not likely present a flight risk.
Now, your adversary, Mr. General Stone, points to a lot of legislative history that Congress intended 1182d5a to be narrow. Virtually all of the history that he points to is a House committee report, correct?
That's right. And it was a committee report that addressed a different version of the statute, not the one that was enacted.
So with respect to this version of the statute, was there anywhere a directive by Congress to limit the number of people?
No, there's certainly nothing in the text of the statute that Congress enacted that places that kind of cap. Instead, Congress directed how parole determinations need to be made, case by case, and it set forth that substantive criteria of the bases for parole, but it nowhere suggested that there is a numerical cap on the number of people who can receive parole.
Now, please tell me how you satisfy the urgent humanitarian reasons or significant public benefit requirements of the statute.
We satisfy that because there is a significant public benefit in ensuring that DHS doesn't run out of detention space to house individuals who are higher priorities for detention because of their criminal records or because they might be particularly likely to abscond or because Congress itself has directed that they should be detained without release under provisions like 1231A2, 1226C. And DHS's judgment in implementing the statute has been, I think, properly interpreted against the background of enforcement discretion here, that serves a significant public benefit in ensuring that it doesn't run out of capacity when someone is a low-priority individual because they don't have a criminal history, they're not a danger to society, they aren't likely to abscond.
How about the issue of whether you have enough resources to detain all these people, feed them, clothe them? If you don't, you're going to let them starve and you're going to have the horrific conditions that have gotten so much public attention, correct?
Well, certainly DHS is committed to providing humanitarian conditions for detention. But I do think that
if you had to detain everybody, could you?
No, and no one disputes that. DHS does not have sufficient detention capacity. Congress knows that. Congress was aware of that in 1996 when it enacted this provision, and there is no indication that Congress intended the safety valve here to be contiguous territory return.
What are the numbers with respect to that, both now and in the past, in terms of the percentage of people who are stopped or encountered or arrested at the border? Think of those as synonyms. I didn't mean to. Versus the number that you can detain.
So let me give you a sense of the current numbers. I'll point to the recent monthly reports that we've been filing in accordance with the district court's reporting requirement of the injunction. The most recent numbers are from March 2022. At that juncture, DHS apprehended about 220,000 people at the border. That was the number of border encounters. At that point in time, DHS was appropriated for a little under 32,000 detention beds, counting some COVID restrictions, some court restrictions in place. And the average daily amount of detention over that same month was also at about 32,000 individuals. That's ICE being a little under its capacity and CBP being over capacity. So I think that it's kind of self-evident and no one disputes here that there is a tremendous shortfall and that DHS could not detain everyone who it's encountering at the border.
Is 320, you say 220,000 come in.
Yes, about 220,000
Per
encounters.
what? Per month, per day, per week, per what?
This was in March 2021.
Or a month.
It's the most recent.
In a month. You're saying 220,000 in a month or up 220,000 in a week or what?
No, in 1 month. Those
In
were the
1
numbers
month.
for March. Now, of
So
course, it fluctuates.
220,000 come to the border, and about 30,000 or so, 38,000 are detained, and the rest are paroled?
Well, there are a variety of tools that DHS uses. They're not all paroled. Some are expelled under Title 42.
The ones
Some
who
put in
are, so
expedited
how many
removal.
are paroled about?
In March 2021, I believe the parole figure was about 37,000, and then there were another 43,000 that received bond or conditional parole under Section 1226A.
So there were 110,000 or 120,000, we don't know what happened to them. Where'd they go?
Many of them were expelled pursuant to Title 42.
I see.
Others were
Okay, so
processed under
half
other
of them, they
provisions
say
of the
you have no business here, and that comes right under here that they're not. Oh, under 42. In other words, under the
public health order that the
on the public
CDC
health
had
order.
issued. And that number, though, also includes other processing under Title 8 authority. So it includes
Now
things like
suppose
expedited
here
removal.
I'm worried about. Suppose I accept your argument for hypothetically. Let's assume that. And then I say I see small b has to do with people whom the immigration person at the border says you're inadmissible, or you want asylum and it tells you what to do. But now we go to our part, which is other people who come in. So I don't know if they're inadmissible or not. Maybe, maybe not. That's what this is number 2. Is that right?
I'm sorry, you're looking at 1225B2?
Yeah.
B?
It says inspection of other aliens. Those are the aliens who are not in the first part, which is the first
Oh,
part.
I'm sorry, you're looking at, B1. So you're looking at the
B1
provisions
are
about-
certain people where they say you're inadmissible, goodbye. Or they say you want asylum and here's a procedure.
That's
Then
right.
it says inspection of other aliens. That's what we're talking about.
That's correct.
Okay.
Yes.
Who are the others? The others are the ones you don't know if they're inadmissible or not?
So these are the ones who wouldn't be inadmissible under the grounds that are specified in B1.
Okay, we got
This
them. That
also
says there
can
are
be
3
applied-
things you can do. One is, as you say, confine them, detain. And then number B is an exception, and number C is send them back to Mexico with the word may. Okay? So we've got those 3 things right equally under the statute. And it says may. So what happens if you say no? And it seems to say shall be detained. And that's what we're talking about. Suppose you just don't detain them, vast numbers. You parole them. You say, I can do that because of 1182. So I got the structure in my mind. But you are not doing what they said, which shall be detained. Well, we can parole them, case by case. Okay, suppose you lose on that. At that point, you have Congress telling you shall be detained, and you're not doing it. What happened? I'm asking you that because the words are important. And the reason I ask you that is this is not the first time Congress has said to an agency, do it. Do it by May 15th. May 15th comes. They haven't done it. That happens more than you might think. Okay, so there's a case law history there of what judges did when the government just didn't do what Congress told them within the time frame they were supposed to do it. Have you looked at that? Do you know what that was? My impression, very vaguely at a distance, was the judge sort of tried to work things out. They sort of tried to negotiate with the agency. They didn't just order them detained. They order the SALT regulation issued because they couldn't. What happened? And does that have any instruction for us?
Well, I think here I have a couple of reactions to that, Justice Breyer, and I hope I can work through them. I first want to push back on the idea of how you describe the statutory structure only insofar as I think that it's wrong to treat this as a self-contained unit. It's not as though Congress sat down at one point in time and thought this is going to be our universal solution for how to deal with these encounters at the border with this class of non-citizen. Instead, all of these provisions were added to the statute at different times and for different reasons. The shall be detained language came in 1903. That was first. Then Congress added the parole authority in 1952 in the INA. And that was actually a codification of the executive's prior practice of granting parole, even when it didn't have express statutory authority to do so. It was only in 1996 that Congress added the C that you referred to, contiguous territory return. And so I just want to push back on the suggestion that this was all at one point in time with Congress kind of thinking about these.
So that suggests the argument that you gave up on. And that was the argument that shall doesn't literally mean shall this instant. It means shall as best you can. Now, you've given up on that argument, I think, or have you?
Well, no, I think shall properly interpreted means that we should use the detention capacity that we've been afforded here. I think the argument and my response to Justice Kagan was that we have express statutory release authorities here, and we think that all of these releases are happening in conformance with the INA. Left off your list as well was 1226A. This is an important source of authority for DHS. This is a provision that applies, as all agree, to anyone who is in the United States. And so that
but these are people that are coming to the border. I thought 1226A does just what you say. It applies to people who are already here. And I didn't think, therefore, it applied to this case particularly, because I think here we're dealing with people who come up to the border. Tell me why I'm wrong on that.
You're wrong on that because DHS's longstanding interpretation has been that 1226A applies to those who have crossed the border between ports of entry and are shortly thereafter apprehended. So that's an important category of the group of non-citizens that we're talking about here. And it memorialized that understanding in regulations shortly after IRA was enacted. And as well, that has been the agency's consistent interpretation across the subsequent 25 years.
The October memo does not rely on 1226.
Justice Kavanaugh, I think that the October memo, of course, wasn't focused on any of these issues about detention or release because the Secretary was making a judgment about whether to continue with MPP. And that was his policy judgment weighing all of the costs and benefits of the program.
No, in the section about the relationship between MPP and statutory mandates, it was all about significant public benefit under the parole authority.
That's right, that he discussed that at length because that is an important source of DHS's authority here. I believe he also referred to the authority that's conferred by Section 1226A.
I need to know this for this reason, that I think, suppose we do exactly what you suggested we might do. May means may. Okay? End of the matter. Then the thing goes back. At that point, guessing, but somebody might say, okay, may means may. You don't have to send them back to Mexico, but you do have to detain them. No, we don't, because of the two statutes you mentioned. Yes, you do, because they don't apply. There'll be an argument. I don't know if, one, we should foresee that argument and take a view, or two, we should foresee that argument and not take a view, or three, we should just forget about that and just say whether may means may.
I think that is the
What's
simplest.
your view?
That is the simplest way to resolve this case. We certainly agree that may means may, and that's really the only issue that's directly teed up for this Court's review in light of the injunction. We are actively litigating those other issues in other cases brought by states with respect to our interpretation of 1225B2A, with respect to our application of the release authorities, and I think that that is a better context where it's not essentially relying on those release and detention authorities as a collateral way to force the reimposition of MPP.
General, I could
Go ahead.
I could understand General Stone saying back to you, well, it's, may means may, but you have to read that may within the entire statutory structure and within the set of authorizations that you have. And essentially, the may would become a shall if you couldn't meet the obligations, if you were using completely residual discretionary authority, right? So that if you couldn't parole people under 1182, give them bond under whatever that provision is, et cetera, and you were just throwing up your hands in the air and saying, well, we have to do something, so now we're operating outside the statute entirely, I could see him saying, well, in that case, the may becomes a shall. It's kind of a springing mandate if you can't satisfy your obligations in another way. So I have to think, am I wrong about this? That your argument depends on the fact that you say you are satisfying your obligations in other ways. If you weren't, wouldn't you have a harder argument?
No, I don't think so. I think that's actually an easy argument in this case. We certainly do think that we're satisfying those other provisions, so the predicate of Texas's suit fails here. But even if this Court disagreed or thought there was room for doubt, there is no way to interpret Section 1225B2C to be that kind of springing mandate. First, there's the textual problem. Congress said may return. On their view, it's been mandatory from the get-go and at all times thereafter, and it would be inexplicable for Congress to use that discretionary language if it wanted to have detention capacity be the trigger. Second, I would point to the significant foreign policy consequences that are implicated by that interpretation. We cannot unilaterally implement foreign contiguous territory return. Instead, each exercise of this authority requires ongoing negotiation and cooperation and coordination with Mexico. And there again, it's implausible that Congress would have demanded that we do that the executive branch engage in those negotiations without saying so expressly and just using may return. Third, I'd point to the history. No one at any point in time during the legislative drafting acknowledged that the provision would have this kind of effect that they're attributing to it. Instead, the history is clear that this was just responding to that BIA decision and overturning the conclusion that the executive's prior discretionary use of the authority required authorization, with no indication that Congress was changing it into a mandate. And then fourth and finally, I would point to the consistent executive interpretation of this provision. No one's interpreted the INA this way before. Every presidential administration has understood this to just be a purely discretionary authority. That goes for the prior administration. On their view, MPP itself would be unlawful because it doesn't maximize the use of contiguous territory return.
General, your interpretation of the statute, I think, is entirely manipulable. You use the statute has what seems to be a serious limitation on parole, significant public benefit, and yet you say that goes down due to the fact that you have limited detention. So, and you have limited detention. It's not like you're going to hit a number there which is going to take care of everything. More than 30,000 are going to come in at a time. And you say, well, it's not. It's actually less than that because we have to save a number of beds for this. So you can have a phrase in the statute mean what you want it to mean to accommodate as many people at the border by releasing them as you want, right? There is no limit, as you read the statute, to the number of people that you can release into the United States, right?
Congress did not create a limit in that statute, but of course it's Congress itself that's making these appropriations decisions about how much bed space to give us.
But if Congress wants there to be the release of a significant or whatever number, all they have to do is not fund detention facilities to keep the number low, and then you would have whatever authority you want to extend the number of people released into the United States to as great an extent as you want. And you say, well, don't worry about MPP. And, maybe that's your decision. But you're sort of making it even harder for you to do anything other than release the people encountered at the border into the United States.
Well, this is a statutory...
Even though, I don't mean to repeat myself, but it's a significant question. Even though the statute that allows you to release people in the United States says there has to be a significant public benefit. And you say there's a significant public benefit when there aren't enough people, there aren't enough beds in detention. So there's no limit at all on how many you can release into the United States.
Well, I think the inherent limit, of course, is the detention capacity. Congress didn't define that term.
I'm putting that to one side
interest.
because everybody knows that's not nearly enough beds to take care of the problem.
That's right. And this has been the agency's...
If you don't think it's a problem, you should add more beds anyway.
Well, this is the agency's consistent interpretation of the parole provision. Congress has never disapproved it. It has known that DHS is exercising its parole authority that way. But, Mr. Chief Justice, to the extent that the impetus for this question is this sense that contiguous territory return could take care of that issue, I want to forcefully push back on that idea because contiguous territory return cannot be the solution here. Over the life of the program in the prior administration, only 6.5% of individuals we encountered at the border were enrolled in MPP. It has inherent constraints. The statute limits who can be enrolled in MPP. You have to be arriving by land from contiguous territory. We're constrained by what Mexico is willing to consent to with respect to who it will allow to be enrolled into the program, and it's placed important limitations on our exercise of that. There were entire categories of people who were excluded from MPP, like all Mexican nationals. Our international commitments, our non-refoulement obligations, likewise provide a constraint here. So to the extent that you are concerned about how parole operates, that concern doesn't go away based on implementing MPP. And in fact, in the prior administration, when MPP was in full force, still DHS was implementing its parole decisions this way, as it's always done consistently for the past 25 years.
Counsel, I'm sorry, General.
Well, I don't want to. I know we're into seriatim, so I don't want to.
Not just yet, Justice Sotomayor.
General, going back to Justice Breyer's question, assuming, just for the sake of argument, that there's no injunctive power in the court below, the way you're arguing, how would we ever reach the question that Justice Breyer raised, which is the district court being wrong on its assumption that this may is a shall? How do we reach that question if the injunction was erroneously issued?
We think that question would be appropriately reached in the case of an individual non-citizen, and there is, of course, jurisdiction preserved to reserve those kinds of claims in those types of cases. This was Congress channeling the review to those cases.
So you would say we should just say an injunction of any kind is improper?
Yes, we think that is the correct interpretation of 1252F1.
Would we need to reach the declaratory judgment issue in your mind, or should we just simply address whether what's before us, which is the injunction, that it's improper?
I think here the court could just reach the injunction and declare that that's improper.
General Prelager, can I ask you a question about significant public benefit? You've identified the number of beds and the need to prioritize as the public benefit that DHS is taking into account and when deciding whether to parole. Is it your position that you cannot consider the significant public benefit in not releasing into Mexico? In other words, that you're only looking at the significant public benefit of releasing into the United States, but not in choosing that option versus the other?
So I think with respect to kind of how this is working on the ground, the individual immigration officers, and there are thousands of them who would be responsible for making these decisions, are focused on the actual detention capacity at that moment. With respect to the broader question, though, about using contiguous territory return versus releasing into the interior, I think that's ultimately a policy judgment for the Secretary. It's not as though return to Mexico is costless. It involves an enormous investment of our diplomatic resources and our engagement with that bilateral negotiation. And so I think that the Secretary is well justified in thinking that in light of the tremendous costs that he identified with the program and in light of his determination that it actually detracted from other strategies and programs he thought would be more effective in stemming the tide of irregular migration, that he was well justified in making that policy determination.
Let me go back to the individual. Oh, sorry.
Go ahead, finish up.
For the individual determination, so you would say that it is not DHS's practice or responsibility with respect to any individual non-citizen to decide the significant public benefit of paroling into the United States versus sending that particular non-citizen back to Mexico?
Well, while MPP was operational, I should take the opportunity to clarify. My understanding is that the officers were making those kinds of discretionary decisions, and in fact, the vast majority of non-citizens who were eligible for MPP, or at least a substantial number, were actually diverted out of the program, and that's why the numbers are only about 6.5% of those we encountered at the border were enrolled in the program. So there was discretion to not put an individual in MPP while the program was in effect.
Thank you. Thank you, General. We'll get back to you. Justice Thomas, anything further? Justice Breyer? Justice Alito?
The parole decisions are supposed to be made on a case-by-case basis, right?
That's correct.
And the statistics that you cite and the statistics that the respondents provided in their brief about the number of individuals who are being paroled every month are very high. So what does it mean for there to be a case-by-case determination? Let's think of the example of people who want to go to a baseball game at Nationals Park. So they all line up, they try to get through the turnstile, and somebody goes through a little checklist. Do they have a ticket? Yes. Do they have a gun? No gun. Do they have alcohol? No alcohol. Something to throw on the field? Nothing to throw on the field. Fireworks? Nothing. No fireworks. Fine. Is that a case-by-case determination in your view?
I think that would satisfy the
and that's what you're doing.
Requirement.
That's basically what you're doing. You got a little checklist, and you're going, and, boom, 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 and that's how you can process. Maybe you're right, but that's what you think Congress meant by a case-by-case determination.
Yes, we think that Congress required us to give individualized attention to each non-citizen and make an assessment about the categories like flight risk and security concern, and DHS is doing that on the ground.
Justice Sotomayor?
Counsel, before the MPP program at issue, I thought that there were a lot fewer people, but there were people who were sent back under MPP, correct?
I wouldn't call that MPP. That's kind of the broad programmatic use of contiguous territory return. I think what you're referring to was the executive's prior practice on an ad hoc basis of sometimes returning individuals, usually.
Then I understood this wrong. I thought that each asylum officer, there were two, I understood from my reading, there were two criteria for MPP. There was a set of criteria that's different than the parole criteria, and that asylum officers determine whether to exercise if the person fit below the MPP criteria, they would be sent back.
Yes, I apologize. I thought you were referring to the prior executive practice before MPP itself was implemented. But yes, under MPP, there was that discretion to choose whether to enroll individuals who were eligible in the program. And of course, there were entire categories of individuals who were excluded from eligibility.
Under the prior administration.
That's correct, and under this administration as well.
Justice Kagan?
I have two rather different questions. First, to go back to Justice Alito's question when he said, aren't you really just using a checklist? And then at the end of your answer, you said, well, what we're doing with respect to each individual is trying to assess flight risk and danger. So that is not just are you a flight risk check, right? That involves something or other. So what do you do with this many people? I mean, you have a lot of officers, too. But what do you do to determine flight risk and danger?
So this relates to the colloquy I was having with Justice Sotomayor, where we conduct criminal records checks, we take biometric records checks, we assess ties to the community, and assess other factors that might bear on the flight risk question. And I do want to push back on the idea that this is anything like just formality going through a checklist. DHS takes seriously its obligation to responsibly allocate the limited law enforcement resource here of detention beds, and it's not as though it's not giving attention to each individual non-citizen to make these determinations.
Okay. My second question takes you to someplace that we have not been, which is the second question presented. And I just wanted to ask, there's a lot of skepticism on the Fifth Circuit's part that there was a second assessment of this question. In other words, the Fifth Circuit said, oh, you're just sort of adding stuff to the first one. So, and you say, no, this was an independent assessment. I mean, how are we to make that decision? What do you look for in determining whether an assessment is new? I mean, the DACA case basically points to two paths that the agency can take, and one is just to kind of use the initial assessment as a base and add some stuff maybe. And the other is, no, you can start anew, start afresh. How do we decide whether you've started afresh?
Well, I think you look in the first instance to the agency action itself. And here, the October 29 termination decision was by its own terms a new agency action. The Secretary said, I hereby terminate MPP. And I think that that's fundamentally different than the situation the Court confronted in the DACA case, where the agency action by its own terms just supplied additional reasoning and said this is not a new decision. This is additional context for a decision that was made long ago. But here, Secretary Mayorkas did the opposite. He took option 2 in Regents. He accepted the remand. He engaged in a thorough process of reconsideration. He showed his work. He described in considerable detail exactly what he did, the meetings he held with stakeholders, those in border communities, state and local law enforcement officials, advocates and proponents for and against MPP. He described the material he had consulted, the congressional records, the litigation records, all of the agency internal memoranda, and then over dozens of pages, he explained the considerations he had taken into account and the conclusions he reached. And I think on that record, this doesn't present a difficult question because there's no doubt that that qualifies as a new agency action. And the Fifth Circuit's contrary conclusion rested on this inapposite reopening doctrine from the D.C. Circuit about statute of limitations issues that respondents aren't even seeking to defend or mention in this Court. So I think whatever hard questions could theoretically arise, this isn't one of them.
Justice Gorsuch? Justice Kavanaugh?
I have several questions. If you had sufficient detention capacity, could you still exercise your discretion to parole people into the United States?
I think at that point, we couldn't count as a significant public interest any resource constraints because under the hypothetical, there wouldn't be those resource constraints. That wouldn't, of course, supplant the authority that DHS has to take into account other humanitarian reasons or other significant public interests. But I certainly agree that at that juncture, we wouldn't be relying on these allocation of resource constraints for purposes of complying with that requirement.
And why is that?
Because at that point, there wouldn't be a significant public interest in trying to preserve the limited resource.
Why would you have to detain them, though?
Well, as I said before, we understand Section 1225B2A to set forth Congress's expectation that we should use the detention capacity that we've been afforded. So we're not saying that's a may or that Congress was neutral on the issue. We're simply pointing to the fact that in this circumstance where Congress hasn't given us the bed space and no one disputes that, it's not only permissible but responsible for DHS to take that into account in its detention and release decisions.
Okay, so you agree that Congress has expressed a preference for detention where that's available? Yes, we do. We don't think that that is a may or simply neutrality on the issue. Okay, switching gears, I don't know if this is before us, so my first question is the State Farm issue with respect to the October memo before us or not? Because if so, I have a lot of State Farm-related questions to ask you. I'll probably ask you them anyway. But is this before us or not?